In a decision that stunned legal experts, law enforcement agencies, and gun rights advocates alike, the United States Supreme Court has issued a unanimous 9-0 ruling that could fundamentally reshape gun rights and search and seizure law across the country. Unanimous decisions at the Supreme Court are rare. Unanimous decisions on highly polarizing constitutional issues are almost unheard of. And yet, this ruling delivered exactly that. A legal earthquake felt from local police departments to federal courts, from gun owners to civil liberties groups. The question now isn't whether the law will change, it's how fast and how far the consequences will go. For years, courts allowed officers broad authority to stop, search, and detain individuals based on little more than the mere suspicion that a firearm might be present. That legal framework just took a massive hit. And the Supreme Court didn't split on ideology. There was no liberal bloc versus conservative bloc, no narrow 5-4 margin, no carefully worded compromise. This was 9-0. To understand the magnitude of this ruling, you need to understand what came before it. For decades, lower courts relied on legal doctrines that effectively said this: if an officer reasonably believes a person may be armed, the officer may conduct a stop or search in the name of officer safety, even if no crime is clearly underway. That logic became deeply embedded in policing practices nationwide. Traffic stops, street encounters, anonymous tips, high crime area justifications. Over time, the standard quietly shifted from probable cause to preventative suspicion. The Supreme Court had previously tolerated this expansion, until now. In this new ruling, the court drew a bright constitutional line. It made clear that gun ownership alone is not criminal behavior, and the presence of a firearm does not automatically erase Fourth Amendment protections. That single clarification carries enormous legal weight. While the full opinion runs dozens of pages, the heart of the ruling can be boiled down to one principle. In other words, the government cannot treat the lawful exercise of the Second Amendment as a justification to weaken the Fourth Amendment. The court emphasized that allowing searches based solely on firearm possession would create a dangerous precedent, one where constitutional rights become liabilities rather than protections. And this is where the unanimous vote becomes critical. This wasn't a political statement, it was a constitutional correction. The justices explicitly rejected several arguments that had been used for years in lower courts. Instead, the court reaffirmed a foundational rule. This ruling doesn't weaken law enforcement, it redefines its limits. Across the country, police departments are already reviewing their training manuals. Why? Because this ruling places clear constitutional boundaries on stop and frisk practices, vehicle searches, and street encounters involving firearms. Officers can no longer rely on generalized fear or hypothetical risk to justify invasive searches. Courts will now demand specific facts, clear reasoning, and constitutional restraint. That shift could invalidate thousands of past searches and affect countless future cases. This ruling also sends a powerful message about gun rights. For years, gun owners argued that expanded police authority effectively punished the lawful carry. If carrying a firearm automatically made someone searchable, then the right itself was being quietly eroded. The Supreme Court appears to agree. By separating lawful possession from criminal suspicion, the court strengthened the practical reality of the Second Amendment, not by expanding it, but by preventing it from being used against citizens. That distinction matters. Had this decision come down 5-4, it would have been controversial, but fragile. A future court could reverse it. Unanimity gives this ruling staying power. It limits judicial resistance, and it accelerates nationwide legal change. This ruling doesn't operate in isolation. It will now ripple outward through state courts, federal appeals courts, police departments, prosecutors' offices, and civil rights lawsuits. Defense attorneys are already preparing motions. Civil liberties groups are revisiting old cases. States are reassessing search statutes, and the most consequential battles haven't even begun yet. To understand why this Supreme Court decision is sending shockwaves through law enforcement, you have to look at how policing actually works on the ground, not just how it's written in textbooks. For decades, officers were trained around a simple assumption: a gun equals danger, and danger justifies control. That assumption shaped traffic stops, pedestrian encounters. Before this decision, many courts allowed officers to justify stops and searches using a legal shortcut. If an officer could articulate that the individual might be armed and the situation could pose a safety risk, then courts often deferred to the officer's judgment, even when no clear crime was visible. That shortcut is now closed. The Supreme Court made clear that reasonable suspicion must be tied to criminal behavior, not lawful conduct that might feel threatening. Carrying a firearm legally is not a crime. Standing in a high crime area is not a crime. Nervous behavior alone is not a crime. When courts previously allowed those factors to substitute for evidence, constitutional protections weakened quietly. This ruling restores the original balance. After this decision, courts will ask tougher questions. What specific crime did the officer suspect? What observable facts supported that suspicion? Was the search truly necessary or merely convenient? Could less intrusive measures have sufficed? Generalized fears will no longer pass constitutional review. Officers must articulate clear, individualized reasoning, and courts will scrutinize it closely. This doesn't eliminate searches, it raises the bar. Traffic stops are where this ruling will be felt most immediately. Previously, the presence or suspected presence of a firearm often triggered vehicle searches, prolonged detentions, forced exits from the car, and pat-downs of drivers and passengers. Under the new framework, those actions require more than a gun. An officer may still act if there is evidence of illegal possession, threatening behavior, a separate criminal offense, or probable cause unrelated to firearm ownership. But without those factors, the Constitution now demands restraint. Expect courts to suppress evidence obtained through firearm-based fishing expeditions, and expect prosecutors to lose cases they once considered routine. Few policing practices are as controversial as stop and frisk. This ruling doesn't abolish it, but it redefines its limits. Stop and frisk was originally intended as a narrow tool, a brief detention based on reasonable suspicion that criminal activity is afoot and that the person is armed and dangerous. Over time, however, the standard drifted. In some jurisdictions, the suspicion of being armed became the justification itself. The Supreme Court has now corrected that drift. Being armed does not automatically mean being dangerous, and being dangerous cannot be assumed without evidence. That distinction forces courts to re-examine past interpretations and forces police departments to rethink future practices. Police unions aren't panicking, but they are worried. Their concern isn't about officer safety alone, it's about legal exposure. This ruling increases civil liability risks, suppression of evidence, internal disciplinary scrutiny, and public accountability. Officers who rely on outdated training may now violate constitutional standards without realizing it. Departments that fail to update policies quickly may face lawsuits, and courts will not accept "that's how we've always done it" as a defense. Behind the scenes, police departments are already adjusting. Legal advisors are revising search and seizure guidelines, firearm encounter protocols, use of force decision trees, and officer articulation standards. Officers are being reminded that lawful firearm possession doesn't equal criminal suspicion, that fear must be grounded in facts, and that constitutional justification matters as much as tactical control. This ruling doesn't demand perfection, but it demands constitutional discipline. Civil rights advocates are calling this decision a watershed moment. Why? Because search and seizure law shapes everyday freedom more than almost any other constitutional doctrine. It governs who gets stopped, who gets searched, who gets detained, who gets arrested.
By reinforcing Fourth Amendment protections in firearm cases, the court indirectly strengthens protections for everyone, armed or not. This ruling limits how easily authority can override liberty. Across the country, defense attorneys are reopening old files. They are reviewing cases involving firearm-based stops, warrantless vehicle searches, street encounters without clear suspicion, and evidence obtained through questionable pat-downs. Many convictions relied on searches that would now be constitutionally suspect. Expect suppression motions, appeals, post-conviction challenges, and settlements. This ruling won't free everyone, but it will change outcomes. Some states may attempt to narrow the ruling, others may embrace it, but none can ignore it. Because this decision comes from a unanimous Supreme Court, lower courts have little room to resist. State statutes and police policies must now conform to this constitutional standard. Federal courts will enforce it. Civil suits will test it. Public scrutiny will amplify it.
It is not pro-crime. It is not ideological. It is a constitutional recalibration. It reminds the nation that rights are not conditional and that fear, even reasonable fear, does not override the Constitution. The most powerful Supreme Court decisions are not always the loudest ones. They are the decisions that quietly reorder the legal system, change how lower courts think, and redefine what the Constitution means in practice. This unanimous 9-0 ruling is one of those decisions. It doesn't just resolve a dispute, it sets a direction. For years, gun rights cases followed a predictable pattern. Courts debated licensing requirements, permit systems, magazine limits, carry restrictions. But this decision shifts the battlefield. The question is no longer just whether the government can regulate firearms, but how those regulations interact with other constitutional rights. Gun rights advocates now have a powerful new argument. The exercise of a constitutional right cannot be treated as suspicious behavior. That argument doesn't eliminate gun laws, but it limits how aggressively the state can police compliance with them. Future lawsuits will cite this ruling to challenge firearm-based detentions, regulatory enforcement tactics, discretionary police authority, and indirect punishment for lawful carry. Courts will now be forced to examine constitutional overlap, not just isolated amendments. This decision creates a legislative dilemma. Lawmakers can still regulate firearms, but they must now do so without relying on enforcement mechanisms that erode Fourth Amendment protections. That means fewer blanket enforcement powers, tighter statutory language, clearer standards for stops and searches, and less reliance on officer discretion alone. Some states may respond by narrowing police authority. Others may attempt workarounds, only to see them challenged in court. Either way, this ruling raises the legal cost of poorly drafted laws. Perhaps the most important philosophical shift in this ruling is what it rejects. For decades, courts implicitly accepted constitutional trade-offs: safety versus liberty, enforcement versus privacy, authority versus rights. This ruling says no. The Constitution is not a menu where one right can be sacrificed to enforce another. The justices made clear that rights are meant to coexist, not compete. That reasoning could echo far beyond gun cases. Expect future challenges involving digital privacy, surveillance technologies, emergency powers, and national security claims. This decision strengthens the idea that constitutional convenience is not constitutional law. Unanimous decisions carry unique weight. Lower courts treat them differently. Law enforcement treats them seriously. Legislators hesitate to challenge them. A 9-0 ruling signals institutional agreement, legal stability, long-term authority. Even future Supreme Courts will find it difficult to unwind this precedent without undermining their own credibility. This is how constitutional doctrine becomes durable. For everyday Americans, the impact may not be immediate, but it is real. This ruling reduces arbitrary searches, limits prolonged detentions, strengthens privacy rights, and reinforces lawful behavior protections. It does not give immunity. It does not block enforcement. It simply demands constitutional justification. In a system where millions of police encounters happen every year, that demand matters. Interestingly, both gun rights advocates and civil liberties groups are celebrating this decision, and for different reasons. Gun rights advocates see it as protection against indirect punishment. Civil liberties groups see it as a restoration of Fourth Amendment limits. Law enforcement leaders, meanwhile, are acknowledging its clarity, even if they dislike its constraints. That rare alignment underscores why the court spoke unanimously. Years from now, legal scholars may look back on this ruling as the moment when the court stopped treating firearms as a constitutional exception, not because guns are harmless, but because rights don't vanish under pressure. This decision may be cited alongside landmark Fourth Amendment cases that redefined reasonable suspicion, probable cause, privacy expectations, and government restraint. It sets a precedent not just for gun cases, but for how constitutional conflicts are resolved. The immediate aftermath will be messy: conflicting lower court interpretations, aggressive litigation, legislative reactions, and policy adjustments. But over time, a clearer standard will emerge, and that standard will rest on one simple idea. This wasn't just a legal ruling, it was a statement. A statement that fear does not override liberty, that unanimity is possible on principle, and that constitutional rights, once recognized, do not shrink quietly. The Supreme Court didn't just decide a case, it reset the rules. And the effects of this 9-0 bombshell will be felt for years to come.